Yanga, are you fine there? Are you ready to? Let us start, colleagues. The Honorable Governor, who's now online, is on her way to the airport. So I'll start with her. She's about to arrive at the airport. So, Honorable Governor.
Thank you very much, Chairperson. Greetings to yourself. I've already greeted everyone in the room. Maybe one chair would just go to questions. Other questions have been dealt with, but maybe I would want to comment firstly in saying, as much as everything that we discuss is within courts of laws, but I really think we must be able to identify amongst the minister and the council who is misleading the House, because we can't have two stories when we are seated in front of Parliament and knowing very well that misleading the House is a problem. So maybe I will leave it to your powers, Chair, to find out what is really the truth and what is lies that is brought in front of us. But I just have one question, Chair, to the Minister. He has been trying to respond very closely to what has been asked in the room. But I would want to really understand that if South Africans would make an assumption of saying it was deliberately that the minister called a meeting with no minutes, no agenda, no nothing, so that it is his words against the council. Because we are seated here, we don't have any profound facts in written, because all his meetings, and in fact all governmental meetings, should be recorded. So we are seated here now with his word against the former board members. So I just wanted to pose a question to the minister. Was it deliberately so that we are running around finding answers, or was there any specific reason why was this meeting not recorded?
Okay, thank you very much, Honorable Governor. I must emphasize the fact that there was no bad faith on my part in convening the engagement with the board, and that my having that meeting with the board was intended to, to get to understand in terms of the concerns that had been raised by the interim chairperson at the time. And that's exactly what that meeting, sought to achieve. I must also indicate, as I've said, that this was not the first time that we've had, that situation where people who are participating in a meeting are, asked to leave their gadgets outside of the meeting. And I think if any of the board members had raised objections, either on the meeting of the 5th of November, where we were having a discussion around the self-review of the board, where I was consulting with the board, and also on the meeting of the 13th. I think if there had been any objection raised by the board or any of the board members around those particular meetings, I would have definitely listened to to such objections. So there had not been any ill intentions or any intentions of acting in bad faith on my behalf, and I had no intentions also of influencing the decisions of the board on any matter, including, as suggested, interference with the process of the appointment of the CO.
No, thank you. Hold on, Honorable Governor. Advocate Lavan.
Thank you, Chair. Through you, we've heard now a few times that the interim or the acting chair had concerns and called for a meeting, this meeting that I myself was not invited to. But I find it somewhat odd that him having called the meeting, he was also not in attendance at this meeting. So I find it very, very curious that a person that calls the meeting to raise concerns doesn't attend the meeting. So I wonder if that was really the agenda. Thank you, Chair.
Just to indicate that my my discussion with the chair was that there are these issues, and I indicated that so because of the agency within which he had raised the issues and the fact that he was going to travel, he did give permission that I can interact with the board in his absence, because what it indicated was that there was a petition towards him as the chair for the for the board to meet and to ultimately take a decision on the on the question of the CO, given the fact that I'd formally asked the board to conclude that process, and so because of that agency, which I'd emphasized, we both agreed that the meeting can go ahead. He had already given me his side of the story in terms of why he felt that it was necessary for that engagement to take place. I must also indicate, Chairperson, that I think it's an important emphasis that we have a responsibility when there are concerns raised, especially by a chairperson of the board, to ensure that we follow through. I think it would have been irresponsible of me, to allow that, what concerned the chair of the board, not to have been attended to, and that's why that process happened. And in any way, the chair would have been available in the subsequent report that the board was to present around how they finalized the process of the appointment of the CEO.
Honorable Governor.
Thank you, Chair. Baptiste, with a yes or no response, I just want to, I want it to be out there and clear. Did you or did you not interfere with the process of appointing the CEO?
No, I did not interfere with the process of the appointment of the CEO.
Thank you, Patiswa. Chair, can you please, the House note that there is an information that is misleading in the House, either from the side of the former board members or from the minister. But all that I wanted to ask about this issue of having reports on the meeting of the 13th of April. But can we further go or move, Minister? The coming to the decision of the administrator, what were the milestones in your head that you wanted to achieve when you came about in appointing the administrator? And in that, can you also please also refer to financial implications or financial package in remuneration of the administrator? Does he have an advisor? If he has advisors, how many are they? And how much is being spent on this? I just want to come to think about it, because we had witnessed that There are administrators that can be put in place without their prepared package, and we have problems afterwards. Have you considered the package and how much is it? And also indicate the measurable milestones that you would want to see as an outcome of this administrator.
Thank you very much for that question. I think firstly that the issues around the terms and conditions of the administrator, especially remuneration and the advice, are being finalized with Treasury, because we will require concurrence from National Treasury in this regard. And I think that if I think members would appreciate the fact that, in our view, this work had to be done, and that the terms and conditions with regards to that has to be exercised with a lot of caution, and regard for the national fiscus, and so on and so forth, and that I think upon finalization of the terms and conditions of the of the administrator's service, we will brief the portfolio committee on that. And then, with regards to the advisory, or the team of advisors, remember that the administrator, in as much as they are competent in particular areas of expertise, there would be those technical expertise that either exist within the institution itself, but also expertise which they may deem necessary, that they can invite to to help to advise the administrator, and all of those includes issues around audit remediation, forensic investigations, issues around public finance, issues around information communications technology and data, student funding, accommodation, legal services, and risk management. So collectively, either individually within the advisory component, or as part of the capacity that exists in the board, the administrator will have to look into those. And then the stabilization plan, or the key milestone, includes, I think importantly, operational continuity, but also the audit remediation, being responsible for consequence management, and then the data analytics resolution. I should say, Honorable Governor and Chair, that I have consistently and persistently been engaging with the NSFAS around the issue of data integration, not just with with SARS, and my last engagement, and the response that I received from the board, which or management, I need to recall whether it was from the chair or the executive management, that last engagement was quite explicit that the process of data integration has not been completed, either with SARS, that there were discussions that were taking place, but that process had not been completed. And similarly, with regard to the HATMIS, which is our Higher Education and Training Management Information System, and so on and so forth. So this is one of the milestones for for the administrator, and then the closeout reports for TVET, the ISU investigations on student accommodation, and so on, and also the digitalization strategy of the NSFAS. So those are the key milestones that we've identified.
I'm hearing you very correctly, but I just have one or two more questions. In February this year, we all sent out a message that was very clear to the public that for once in a lifetime, we think NSFAS is actually becoming stable and is responsive to the challenges on the ground. Now in May we are here. The developments from February till now, what was so hectic that we find ourselves in this situation now, in terms of how we have combined all the resolutions that were taking place in just 2 or 3 sentences? What has brought us into this? Because we all have been sending a message out there that things are stable. And what does this mean to NSFAS beneficiaries in the country? Because where we find no stability, it affects them directly. Because I'm trying to figure out, will the administration have any bad impact on the beneficiaries themselves?
Firstly, and I think that's an important question, this administration can only have a positive impact, to complement the work that the executive and staff at the NSFAS has been doing, and that none of the actions of the administrator is meant to affect student allowances. In fact, it is meant for us to actually, stabilize all of these issues that that I've mentioned. So that's the first. The second thing is that I've indicated that from October last year to I think around the 13th of April, which was the last meeting engagement that I had with the board, I'd cumulatively met with, and I must emphasize this, I know the former board member, Advocate Ramashia, indicated that it was not 20, it was 5. I was very explicit that it's a split between my meeting with the board itself and also my engagement with the administration, meaning the acting CEO and members of the administration. So those 20 engagements were not necessarily with the board itself. That number includes. So all of those were intended to support the board to ensure that we have a proper reopening of the academic year. Also, I must and maybe to use a sport analogy, is that a team can be good today and be bad the next match. So if you look at the statements that I made in February, most conditions, outside of the other issues that I've mentioned, the board itself, its composition, and so on and so forth. In my view, at the time, are what I referred to, which is being, quoted. But in April, the conditions were different. You've had now, again, an interim chairperson who've resigned, together with, the chair of the Human Resource and Organizational Design Committee. So situations can actually change, either in a much longer period of time or in a short space of time. I mean, if you look at the series of resignations that happened, the first one happening, in the first week of August, hardly a month of, being in office. And at the time, I was not even, aware that there were protests around the composition of the board, where the deputy chairperson resigned. And then, I think a few months later, the chairperson then resigned, Dr. Stander, together with 3 or 4 other members. So things do not, I mean, at the time when I went into office, there were 14, I think, not 14, but, a full composite of the board, and in that short space of time, about 7 or so members had already resigned. So a board can be good on a particular day, and so forth. And I think it also applies with the self-review, that a board may be appointed not on the basis of the legal prescript, but it does not mean that that board will not effectively function. And like I said, I mean, the board had, in that financial period, about 28 meetings or so. So I think we have to. So the one does not necessarily mean the other. If I say that stipends were paid, and so on, of course, to suggest that there were no protests at all, myself, Honorable Lonzi, Msezana, yourself, Chair, together with some members of the Portfolio Committee, ourselves were outside of Parliament when there was the question of student accommodation on a weekly basis. In the meetings that I was having with the board, in the war room, those meetings were intended as, to stabilize, to stop the fires, to attend to issues in real time when, they're supposed to. I think in almost every second meeting, the student leadership would come with a set of issues, and some of them even, threatened. So all I'm saying is that it was not exclusively the work of the board, that things work. And I'm not suggesting that they didn't play a role, but I think to fully attribute that to the board, even on tasks which, exclusively, and just to mechanize. If the board, just a last point, Chair, the board can take proper decisions, and they can have an executive management that doesn't follow those decisions, and so forth. So I think to relate the 2 points, would be quite unfortunate. The reality is, as the situation obtained, and based on my consultation with the former board members, as the reality obtained on the 4th of May, I strongly believed that in order for us to be able to save and stabilize the National Student Financial Aid Scheme, we had to introduce, an administrator. Thank you.
Okay.
Chairperson, just one last question.
Yeah.
Minister, there are allegations of people under your leadership, that is under your management, the administrator of sector, the person in your office, allegedly called the former board members. Where we are seated, would you in the form of responding to the question that we have in our minds, why will these people or these certain members that are alleged to call the former board members speak something that we have not sent them to say what was what did they stand to gain for lying? If you stand firm that you did not send them, what are you going to do with them in finding out what we have found out today? Because if you say, Minister, you did not send them to speak anything that was on your behalf, what measures are you going to take in place to correct the lies that have been perpetuated around your name, and also about the integrity of the seat that we are sitting in, because that seat belongs to an organization?
Well, yeah, maybe just one comment. I think I'm as much your serving as your Minister, Honorable Governor, as much as I'm serving as Minister for Honorable Lonzi and everybody else.
And
but
Honorable Ngubani of
Ngubani,
even though there they want
and how I can go on, but I think that the point is that the said people are not here to present their version of the events, and hopefully when they do get an opportunity to do so, they will, and I think those issues will have to be dealt with on the basis of their merits. I don't think I'm placed to make comment now on discussions which are was not made private to. So and I'd like to leave it at that.
Lonzo, what does your follow-up?
I had a follow-up on a question of Govan, but I wanted to also remind you of the earlier thing, because I think you'll forget it, Chair. You don't want to give them, or I must ask.
Do you still remember the question, Advocate? Yeah. What was the follow-up?
This new one or that one?
That one.
Or that one. No, I was saying when the minister was responding, he says that when he was listening to the discussions here, the board members have not made any claim that he gave them an unlawful instruction. And I said I differed with that because the way I understood them, they were actually saying substantively that the minister gave them an unlawful instruction. So I wanted them to confirm that just for the record, yeah.
No, thanks, Chair. I remember the question. I think the what I understood the minister to be saying, and I agree with the question, what the minister would have said will not be correct. We did say, and we said this, and because I said we have got a different understanding of the principle of sub judice, we said it in our court papers that we understood the meeting to have been an unlawful meeting and unwarranted. We did canvass the idea before today.
Okay.
And then my follow-up on the issue, it was when the minister was talking about the number of board members. So on slide 8, the minister says there by April 2026, board had 7 or 18 members, then says no chair, no deputy chair, no acting chair, and then says had failed to comply with directive and purported to appoint CEO without concurrence. And maybe this question I put it to legal again, because the NSFAS Act says is concurrence on the terms of service. Now, I wonder if the legal of the department would want to explain that important distinction to us. What is your understanding of concurrence of the appointment and concurrence of the terms of service?
Yeah. Advocate Kuta.
Yeah, can I come back to the question? I just need to check what
Okay.
you said. Yeah.
No, it's fine.
Thank you.
Honorable Nguban.
Yeah, thank you very much, Chair. Yeah, to me, I think, Chair, still I can't ascertain the real reasons for the minister to put the NSFAS under administration. I think one of the statements was quoted by, I think, a gentleman, the one for the 24th February, where the minister himself said for the first time NSFAS performance has improved. And then he said for the first time as well, first time entering students knew their funding status before matric results were released. And continuing students knew their status before the end of the previous academic year. And there are many other statements that the minister has said which showed that really now there is an improvement in NSFAS. There are many. The other one is the statement on the portfolio committee on 25 March 2026, and then on the 14th November 2025. And even the gentleman here has confirmed that there is a whole lot of things that they've done which show an improvement in NSFAS. The request again for me is to revisit again the question to say, which is the specific reason that the minister can give us to say, really, these are the reasons because it's holistic reasons that are put on front end. I'm trying to nip at least one that maybe can say, maybe this is the real one. All of them doesn't match up to what I'm getting as a feedback to say, from way back at this juncture, this NSFAS, for the first time, there's been an improvement in NSFAS.
Look, firstly, I think it was probably an error to indicate that this was the first time that students knew, the funding decisions before. It may not necessarily have been all the students, and it may have had its own challenges.
So it was an error on your statement.
And similarly, if you can just allow me to finish. Similarly, with regards to this year, it was not without its own challenges. Now, this does not in any way take the fact that the NSFAS, and it's, well, the NSFAS, firstly, the executive and the administration, worked around and being supported by the department and all of us to make sure that it meets that particular milestone, and the role that the board had performed. But it does not take away, the fact that there were all these things that were happening in terms of the board itself, and I think we need to make that distinction. That, and as I said, that an entity can do those, can disburse funds, can make sure that students are paid on time, and so on and so forth. But you may still have the challenges that were raised by by GTEC. You may still have challenges raised, by the AG. You may still have the challenges that were, occasioned by the successive resignation of the NSFAS board members themselves. So that's why I said that we need to make a distinction between the two.
But I'm saying, Minister, you mean it was an error on the statement you were saying of praising NSFAS?
No. It was not an error to praise NSFAS. So it is important that we, all, and I think that's the sentiment I suppose you share, that comparatively speaking, with previous academic year, the challenges that we normally face in terms of disbursement of allowances and so on and so forth, but also as it relates to protest, that those were relatively lower, comparatively speaking. So it wasn't a mistake to mention that. But I also think that it may have been overzealousness, on our part to suggest that some of the things were only happening for the first time. Some of the systems were, of course, in place, that were in place even in previous years, with regards to allowances, with regards to, and so on and so forth.
Now, that overzealousness, Minister, is noted, yeah. And then here you are, everything is going very well. You're even giving the board instructions to go ahead and appoint the CEO by the 31st of March and many other instructions. This board that was doing very well, turning around NSFAS, and while they are busy doing that, and there's even that panel review that you were still waiting to get its output. And again, with all those, so you chose then to just stop that, to stop those instructions and everything, to say now, if on the probability of scale of reasoning of putting the NSFAS administration, now all that instruction you've given and the review. Now the other item, it says now the NSFAS must be put under administration.
What tanda masita? Even when we're talking about NSFAS, it's a slip of the tongue, but that's okay. That's the other preoccupation which we have. If you may allow me just briefly just to explain the self-review. So I approached the self-review process in good faith. My intention was not to put blame on the NSFAS board. My intention was to ensure that we set the decision that has been taken to appoint this board, aside, so that we start a new process. And that process could have been anything else. It could have either been, gazetting, nominations, and so on, or it could have been, an administration process. And this process of the self-review started, officially when I engaged with the board on the 4th of November, but it was a process that had started even much earlier, I think a month or so earlier than that. So it has it's now, I think, having a life of its own, and I think the date of that will be determined. But I think the important distinction that we need to make is that that application was made under different circumstances. circumstances within which, there was a chair, and I think there was about 12 members that were, that were remaining in the board, and we were also legally advised that the only way in which we can, set aside the board is only by approaching the, the court. So it's a different set of circumstances that necessitated this. Now, so we didn't have the resignations, as I said, and a series of other things which I have explained, which led us to, to the decision to appoint the administrator. I think I quite extensively indicated what those reasons were in the board, and I accept that this would be issues of difference, but I think the facts are there to speak for themselves.
Okay, all right, and then Minister, coming then to this appointment of the CEO, there is an information that I don't know whether the board members will confirm that. There was a first advert that went out publicly for the appointment of the CEO. And then there were respondents, right? And then was there another second set of trying to fix the list of the applicant, to correct it or to make it, if there were any other corrections? Or there is a perception that there was an advert, and then I don't know whether it's you, the minister, or the board, and then the applicant, the response was looked at of the candidate that applied, and then someone said the candidate is not gender reflective, there are not enough women. Then they need to go and look at how can they have women. Was that from your instruction or from the board or the HR committee?
I honestly don't remember. I may have to look into that, but my recollection is only that upon the board requesting me to approve the extension of the acting CEO, I then instructed them to further, upon concurring with their decision to have the acting CEO's contract extended. I also, in that same letter, because I was concerned that the acting CEO was acting for more than a year, so I then put the ultimatum that the process for the appointment of the CEO had to be concluded on the 31st. I mean, the rest of the stuff I may, I think recall from memory as to why, there was no appointment. I was mostly concerned with the fact that at that point, when the board was asking me to extend the acting period of the CEO, that there seems to be some tardiness as it relates to the appointment of a substantive CEO.
So there was no sort of like looking at the list of respondents to say, as far as I see, there is no reflective of gender on the list of candidates from your side.
I don't remember. I don't remember seeing a list of candidates. I don't remember. I'm not saying that there wasn't, but I'm saying I don't remember those candidates being presented to me. I have absolutely no recollection of such a thing happening.
Okay. Were there two sets of recruitment, one called advertisement and one called headhunting, in the process of recruiting the CEO? Can I get, if the board members here can confirm that, if the minister doesn't know that?
Through you, Chair, yes, it is true, Member Ngubane. We did run the first process of recruitment, and then exactly as you are saying to say, we had to go back again through the headhunting process so that we were able to address the gender imperative. It was a resolution of the board that was direct to say it should have a gender balance. The candidates, yes, thank you.
Okay, all right, so that process happened, and on that addressing the gender balance, and then boom, we see Mr. Busani Ngaweni coming in. And again, there's no gender footy there. And then the male are still coming in, but now the process looks legit, whereas there's no gender address.
Yes, you are correct, member. Thank you.
So would I be correct then that the second process of headhunting was to slot in Busani Ngawin on the list so that he becomes a candidate that is going to be chosen as the CEO of NSFAS?
Not in as far as the conceptualization of the board was. The board received a report which had recommendations from the HR committee indicating exactly what my colleague says. The intention of the board was to ensure that there is a representation of female candidates in the process. But my colleague has already confirmed what you had asked, and I would agree with you to an extent that you may say that a perception may be sustained in that respect. I agree, but that was not the understanding of the board.
Okay, Chair, this is information at hand.
Yeah, hold on.
My hand is up on the platform.
Yeah, hold on. Hold on, Honorable Nguban. Thandi, I'll come to you, Honorable Maime.
Thank you, Chair. I just have a question about my understanding. I'm not sure whether the names of people that are coming up as part of a confidential process. I'm aware that they were in newspaper reports. I'm not aware that this Parliament has discussed what is actually a confidential selection process. The reason I'm asking that is because I was part of that selection process, and I'm not very sure why we are discussing a confidential selection process in this format. I am aware that there has been some allegations, discussions in the media, but I'm just wondering if I'm asking about the legality of that, Chair. Thanks.
Okay. Honorable Maimela.
Thank you very much, Chair. I was coming in on that point, that I was worried that you did not call Honorable Ngubani to be cautious on this matter. As members of the Portfolio Committee, in the presentations that we've received, there is no names that we've received that are on those presentations. And seemingly, Honorable Ngubani then might be using information that we're not privy to, that was not presented in this Portfolio Committee. And I'm worried because if it is information that was presented that somebody else have, I would also want an opportunity to engage with that information. So he mentioned a name, and I don't know where do we get this name from, the presentation, official presentations of the department, or is it that we're discussing this name on the basis of some media presentation as the official of the department has just said. But I'm very worried about doing that, because if we delve into that, there's many other names that we're going to be dropping ourselves who are coming after, and we have been cautious in our preparation of questions not to do that. So, but if you allow Honorable Ngubani to do that, we are also going to delve into that. I was just raising that caution.
Honorable Lonzi.
Chair, I'll allow you to make the ruling on the name of a person, but I think where I want to come in is that it would be incorrect for members or anyone to suggest that Honorable Ngubani is trying to target someone. The way I understood his question was that the department goes to advertise, and then the results come back. And then the results come back and they give a report that we don't have enough female representation. They then say, because we don't have female representation, we are going to go and start a headhunting process. But what becomes questionable about this process is that it does not bring back a female. That's the spirit of his question that I understood it. Maybe on naming of people, I'll leave that to you, Chair. But the spirit of his question is that it seems as though this headhunting policy was, even if the intentions initially were genuine, but the perception that goes out there is that it did not achieve what it intended to achieve. I think I'm just coming in to That's how I understand Honorable Ngubani's question.
The reason why I might have added the name if the name need not to be mentioned. I might add the reason, Chair, why I'm asking that. It's because
maybe let's make because an order has been called.
Yeah.
Caution you that don't mention names of people.
Okay.
For the credibility of our meetings.
All right.
You might have that information, and other members don't have it, and it makes it difficult.
Yeah.
So maybe let's not add names of. You can still make a point,
Okay,
without
all right.
necessarily going into.
Okay. The point here, Chair, I'm trying to make is the information we've been given of the administrator of services SETA, which the name was given to us here, who said there is an instruction for a specific a name to come up, which gives us this information that somehow the first advert went out, and then as the process goes, it was realized that there is a name that is not in the list, so that name needed to be slotted. A second process was started called headhunting. And when the second process for headhunting was going on, a new name came up, and this new name is the one that we have found ourselves being seated here today, that was purported to be elevated as the one that will be the CEO. That's the information I wanted to bring. Okay, and then coming to the next question, Minister.
Minister wants to make a comment on.
I think just to indicate, because I think Honorable Lonzi said the department advertised, so this is a process which was fully in the hands of the NSFAS, as the department were not involved, and that's why I don't have recollection, and I actually am reminded. I'm benefiting a lot from the report that they're on. So it's not something that I was involved in. I'm not aware of that.
Yeah, okay. No, I think the information, I've got it. It's confirmed that what I'm saying, it did happen, of two processes of recruiting, the one called advertising and the one called headhunting, which a new name came in. So did the minister instruct board members to hold the CEO process for him to conduct political consultation?
No.
There was no instruction of that nature.
No. What I said to the board, to the members who were in the meeting, was that they should conclude the processes. Sorry. They should conclude all the processes that relates to the appointment of the CEO before going ahead to, to appoint the CEO. So I didn't say that they should hold the process. I didn't say
for
that,
political consultation.
No.
Okay. Did you advise the board that you need to be briefed on the outcome of the CEO process as they deliberate on the matter as it goes on?
No. So I think the point that the point that need to be understood is that the meeting was because of the concerns that the interim chair had raised around the board members petitioning him to want to have a meeting of the board to finalize the appointment of the CEO, and the interim chairperson's concern was that that meeting may go ahead before the board had concluded all the internal processes, which included, I think, as I had in the meeting I had with the board in the National Humanities offices, was that the HR process, Human Resource Committee, an organizing committee had not completed, and that the board will go ahead. And I asked the board that upon conclusion of that process, they need to indicate to me and that they are ready to proceed, with the appointment of the of the CEO. And I think for me, the important thing was that all the processes that the board needed to follow before the board meets to decide on who the CEO becomes, should have been, all the boxes should have been ticked.
It's a follow-up.
No, finish first, Ngubane.
Okay, all right. The minister, there is a perception that you engineered the resignation of the two board members. Will that be correct?
I have not engineered
for the purposes that the board did not do the process the way maybe you wish it to be.
People have been resigning in the NSFAS board. I mean, the chairperson resigned, substantive chairperson resigned, the deputy chairperson resigned, 4 board members resigned, and following that, an interim chairperson of the board resigned, chair of the HRODC committee resigned. I think if with whatever powers that I can have to suggest through perception or insinuation or innuendo that I may have engineered the resignation. But I also think it brings, into question the reputation of the, of the board members, all of the board members who served, and I think they themselves have consistently repeated this, that there are people that I hold in high regard. And I think if any of them, would feel that I have in some way or another, pushed them to either resign and so on, I can just imagine instructing Dr. John Mugwena Maluleka to be seen. I deny any involvement in the resignation of any of the board members who have resigned from the board. Of course, I was concerned. About that, and that's why I think it necessitated, whatever action.
Okay, Advocate Kuda, you are ready for us.
Chair, thank you, sir. Thanks for the opportunity. I've checked the Act, Section 9, subsection 3. The board must, with the concurrence of the minister and the Minister of Finance, determine the conditions of service of the executive officer. And I think the question was it coming from you, Mr. Lons? Can you please repeat the question?
The question is,
yeah,
the concurrence issue, is it on the appointment of the CEO or that service level agreement or whatever how they termed it? Conditions of service.
Yes, thanks, Chair. The Act as it is just refers to the conditions of service. And my interpretation, Chair, would be that why would a must be used for the minister to concur on the conditions of service whilst he was not involved in the actual appointment, and saying, I concur with this particular candidate that you have put forward as the CEO. For me, I took it that the concurrence would have occurred first with the name that is put forward, because the conditions would be linked to the particular CEO that is appointed. It won't be applying to anybody.
And why do you think that part is not covered in the Act?
I'm trying to check the charter, what it says, and unfortunately, I didn't bring the copy of the charter, but the Act is very clear. It's about the conditions of service. But for me, I feel that there is a gap, because there is a must that the minister must, with the Minister of Finance, deal with the issues of the conditions of service. But who are they dealing with here? Because somebody whose name would have been put forward and they would have participated in saying, we agree with this name, and therefore, here are the conditions of service that we will agree with or concur on.
So you agree with us that what we've been singing all along, that the acts that we have got serious gaps in them. So I'm happy you now agree with us, because that's the point we've been saying. Not only the NSFAS Act, the CET Act, the Higher Education Act. So I'm glad you agree with us. But the question was, yes, there's a gap, we agree. So, but the question is, does it speak to the condition of service, or does it speak to the concurrence on the appointment, as it is now? Let's leave the gaps part. The Act. Yes?
The Act does talks to the conditions of service.
Okay. Minister?
Hence,
Yeah.
sorry,
Yeah.
Chair, hence, I was hoping that the board charter would have covered something around the actual appointment or the actual recommendation of the name of the particular candidate. Thanks, Chair.
So you need more time to check the board charter. Okay, how long? Maybe 30 minutes. No, I'll give you now, Minister.
Okay.
You'll check it now, the board charter. Okay, thanks. Minister?
I think just, I don't know if that would be necessary, because in my head, I have no doubt in terms of what is required of me and what is required of the board. The board appoints the CEO, and upon appointment of the CEO, the board seeks concurrence in terms of the conditions of, the terms and conditions of employment. And I've consistently understood this, to be the case throughout.
No, thank you, Minister. I think we're on the same page. You wanted another? Okay.
So I think the minister is helping us a bit, because advocate probably was running away from this question. And the reason this is named is the reason I asked advocate this question, Minister, because if you go to your slide 8, you mention the board not listening to a directive, and it's how you write it. Maybe let me go to it so that I don't just paraphrase it. You say there, Minister, that, sorry, Chair, I just want to read it correctly. The minister writes on slide 8 that failed to comply with directive and purported to appoint CEO without concurrence. Now, that's a very problematic statement. Worse when you have explained your duties the way you have explained them. Because you correctly point out that in the NSFAS Act, and this is why I don't take advocates' explanation, the Act is very clear. It's not the job of the department to rewrite the law, it's the job of Parliament. Parliament has given the powers to appoint to the board and given the powers of concurrence of terms of service to the Minister and the Minister of Finance. So why would the Minister then, in the presentation, say, purported to appoint CEO without concurrence? They don't need the concurrence of the Minister to appoint the CEO. It's the board function. They only need the concurrence when it comes to the terms of service. I just wanted to make that point, Chair.
But importantly, the process of appointment does not only end with the decision of the board. The process of appointment and assumption of duty ends when the Minister of Higher Education and the Minister of Finance has concurred. So that line is not inconsistent with with that provision in the slide.
Okay. Yeah. Okay. Dr. Mukadi.
Thank you. I think just for the Member of Parliament's notes that even the current administrator does not have the concurrence of the Minister of Finance, and that's what the Minister would have presented there. So when the appointments take place, it's very important, I think, for the point of discussion. Yeah, assumption of truth. Thank you.
Honorable Khacha, you want concurrence to speak?
Thank you, Chairperson. Chair, let me firstly be clear on this. There are a plethora of reasons available not only to the public, to this House, but to your office, Minister, that justify why you wouldn't want the CEO and the then board to continue doing their job because of a plethora of reasons. That's not my problem. My problem is that your approach was clumsy, Minister. You had one job. Your job was to make an analysis of whether NSFAS in its then composition made sense, was delivering service delivery optimally, whether the leadership was desired, and by desired not by your own political desirability, but desired in that were they able to do their job properly or not, and based on that make an assessment of whether life continues or whether life changes. So that's fine. And the Act says you can put them under administration. Yours is just to have a consultation with the board. And even the Act doesn't say they have to agree. You can just have a consultation. So that for me is not an issue. My issue is that your approach was clumsy. Let's park that. My biggest problem with you, Minister Manamela, is your choice of administrators. So even if I, under any circumstance, want to believe that your intentions for placing NSFAS under administrations were pure, because of your natural choices of administrators, not only for NSFAS, but even for SETAs, that automatically poses doubt in my head of the intentions you have on the basis of your choice of administrators. I'll recap, right? Let's first go to your SETAs administrators. I wrote to you on the 19th of August, 2025, giving a short summary of why the choices of administrators you chose for your construction SETA, local government SETA, and services SETAs were problematic. And you would note that I didn't have a problem with the reasons why you placed those SETAs under administration, because I agree that they are a problem. In fact, they shouldn't exist in their current form. So that is not a secret. But if you want the Republic to believe that your intention is to really fix what is wrong, you need to be able to convince the Republic that the people you are giving the mandate to go fix what is wrong, not only themselves do they have the intention to fix what is wrong, but that they have the capacity to fix what is wrong instead of creating more problems. As you said, you cannot till date still justify why Upangwane is the administrator of the construction SETA. Beyond his implications through his jobs that he has done with government in the past, including the Mfuleni local municipality, with construction SETA alone, you still cannot give us confidence that that man is the right man to fix what is wrong with construction SETA, because he himself has his own issues, which is the basis why I've laid criminal charges against him. You have Zukile Mvalo, your DG, who's been the boss of Zukile Mvalo for all the years of Zukile Mvalo, cannot justify to you that Zukile Mvalo's performance as DDG of skills development is so impeccable that he has the sole expertise in this country to fix what is wrong with SETAs in the country. You yourself cannot do the same, which is why that is not the reason why you gave that is not part of the reasons you gave the Republic for choosing him as the administrator. He himself is the wrong person to have even tried. He has zero capacity. He had zero capacity to manage his own diary, let alone his ability to whip any SETA into action. So he had absolutely no business being your choice for local government SETA. We'll have another conversation as to why he's even messing up now as administrator. And then you have Ntatele Tlhogonolo Masog, who for some, they could argue that he's an agent of compliance by himself and nothing else. Not only is he a politician of the ANC known for his track record in Limpopo, in the Limpopo legislature as Speaker and as MEC, but The whole entire Makaro Masina SEZ's problems have his fingerprints all over them, and you know this. You have forensic reports that tell you this. This is information you know and have at your disposal before appointing these people. Now you have another opportunity to say, okay, NSFAS is a problem for the country. NSFAS is a problem for young people. We still have an ICT problem. We still have a disbursement funds problem. We still have a missing middle problem. We still have a student accommodation problem. We still have infrastructure I can list a whole lot of things that are still a problem. I want somebody to fix it. And the first person you think of is somebody that has not been cleared of a report that details flaws of mismanagement as the South African Reserve Bank. I mean, if we didn't have problems with your person of NSFAS, he would still probably be at SARS and living a happy life he would have, even his salary would probably be at 4-point-something million by now. You know his track record is a problem. You also know, Minister Manamela, that not every criminal is behind bars. So you can never say that until there is a court of law that has convicted a person and put them behind bars, we can't assume there's anything wrong, also because the public service and administration has not found anything wrong. You know very well, even including the board that you now wanted to get rid of at NSFAS and its CEO, your office knows that there are people who are there who should have never been there to begin with, which is why you're part of the reason why you're trying to get rid of them is because you have knowledge of things that the PSC can commit to but has not. So sitting here as a member of parliament, I have a problem with you and your intentions. You identify a problem that is clear for anyone to see. In your identification of the problem, you then decide, in your decisions of who comes to fix the problem, you create an even bigger problem. Do you accept, Minister Manamela, that you have failed to show the Republic that your intentions, on the basis of the choices of administrators you choose, are honest?
Thank you very much. Firstly, I think my intentions are very clear. They're about ensuring that correct the issues that you've mentioned, which you believe are the issues that affect the institutions, which we have gone ahead to place under administration. That's the first thing. The second thing is that I think the question of the seaters that are under administration, all of those seaters that you've mentioned, the work of the administrators of those seaters. I think all the three seaters, their administration is being wrapped up. And I think we will need to look at the reports, from that administration of the three seaters, which is the construction services and local government seater. I still believe, and pending, the reports that I've requested in terms of the terms of these administrators, I still believe that the decisions that I've took then still remain consistent. As much as you remain consistent with the fact that you had said to me in August, and you're still saying to me now, that I was wrong, and specifically with regards to your letter, which I've asked that the department give me a report specifically in terms of the construction seater and the issues that you've raised. You have said that you have opened a case against one of the administrators, and I suppose the law has to take its course. But what is important for for me in terms of the people that we've identified to stabilize the institutions that you've mentioned, is firstly that they are fit and proper as defined by the different set of pieces of legislation that led to their appointment. And secondly, that their own track record, should speak to it. And I think specifically zooming into the.
I'm going to pause you there, Minister. Minister, there's nothing you are going to say in this meeting today that is going to convince me that the gentlemen you choose and you have chosen as administrators are fit and proper. You can quote any legal clearance of the PSC administration, even the law itself. There's nothing that's going to convince me, particularly because you and I both know, Minister, that just because you have not been caught behind bars and convicted, it doesn't mean you are clean. Yes, you are guilty, you're innocent until proven guilty. But we know, because we even know your own organization, the ANC, has instructed Sisi Tolashe to resign as a member of parliament and as a president of the ANC Women's League. Not because any court of law has found her guilty of anything, but because we know that you don't have to be behind bars to be guilty. Yeah. The President of the Republic of South Africa has fired your predecessor, Nobuhle Ngabane. Not because she's not behind bars. Yes, the Hawks are still busy with the case are open against her. But not because there is any court that said she's guilty, but because the president knew that which we accused her of is guilty. So the bottom line is we are never, and anybody who is a person of the Republic of South Africa knows that not every gangster is behind bars in our neighborhoods. We know who they are. They are our uncles, they are our brothers, our fathers even sometimes. So that's not an argument that you're ever going to win with me today. Yeah. The point I'm making that I want to plead with you here is because actually, for the first time, I agree with you and your things that you are doing. It's this NSFAS is failing. NSFAS in its current form does not work. I agree with you, and which is why the position I've consistently made to you is that you need to, in order to ensure that there is an effective functioning of the dream of funding poor students in this country, is to do what the Minister of Finance has already advised you to do, which is we can save so much money by just giving Treasury the mandate to handle the finances without involving an entity that in its composition is a problem. The only thing missing is your political will, right? But you chose a compromise approach, which politically I understand where you're coming from. We don't sing the same Catership scorebook, it's fine. But I understand your compromise and the situation you are in. But you cannot, under any circumstance, Minister, convince the Republic in all sincerity that the people you are saying must go fix what's wrong have the capacity to fix what's wrong. They are not. They're not the right people. They've never been. And you're making my life difficult as a member of parliament who understands what you're trying to do here with NSFAS. But because your choice of an administrator is compromised, you're making me gaslight myself.
Can I just say something, just briefly, that I'm not saying that. Well, I'm not going to try and win an argument, as you suggest. I don't think that that's what I'm trying to do, at least. Secondly, I'm not trying to persuade you to believe what I'm saying. And what I said was that the terms of the administrators that you've referred to, are coming to an end. And I think that there are reports. And I'm saying let's judge them on the basis of those reports. And I think the rest of the other points, as you said, that you are not going to be trying to, I think, argue or win an argument with me. That's not what we're trying to do. I think just to try and present the points itself. And also all I'm prepared to say is that we, have given the NSFAS administrator scope and milestone for him to achieve, with consistent assessment, over time. And I think we should give him an opportunity to be able to do his work.
Final question, Minister, on the administrator of NSFAS. The Nugent Commission the reports of those commissions, were they ever set aside in any court of law for the Republic?
Not that I'm aware of.
Okay, so you, as before an executive member of the state, as a member of parliament, knowing fully well that there's a commission that made an assessment of the South African Reserve Bank, and knowing that that commission's findings have never been set aside in any court of law, can you, with all honesty, justify to the Republic that your choice of administrator for NSFAS in the form of Ndate Mathebula is the correct one?
Yeah. Like I said, I mean, subsequent to whatever happened, with the Nugent Commission, which is, was an important investigation which resulted into the turnaround of the institution itself, which Prof. Mathebula himself had, per the report, indicated that he'd cooperated with the commission. He has subsequently served not just in private entities, I don't want to name them, but also public entities. He's I think just as he was appointed as administrator, was also serving as the chair of the MDDA, which is an entity of government appointed by the president. But he's also served, or he was at the time of his appointment, the head of the Tshwane University of Technology Business School.
Ndate, I'm going to pause, Chair. We already know you've told us these things. My conclusion is
you've
this.
Asked me the question, and I think on the basis of that...
No, Minister, the Aralwane.
Yeah. Well,
so
I'm
the
not
point I'm
fighting.
making
I'm
to
just
you
saying
is
asked
you
me a
don't
question,
need
I'm
to,
trying to
you don't
respond to
have
that.
to go back to reiterating his qualifications. We already know. That's not what I was trying to establish. The point, and my prayer was for you to receive it with the sincerity I was giving it to you, to say, you cannot, under any circumstance as minister, want the Republic to have faith in you and your intentions if the physical proof of your actions do not afford the Republic the opportunity to trust you. I certainly do not trust that in your intentions of clearing what is wrong, that you are choosing the right people for the job. And I don't think South Africans trust that either. But my 15 minutes ends here. It's fine. Thank you.
Thank you. Are you okay? Honorable Souls? Before, Advocate Kuta, did you win with that? I know the minister cleared it, but you did not win with it.
Chairperson.
Yeah.
I think it's good. I think
I was even I was even trying to offer to send you the charter. Honorable Souls?
Thank you, Chair. Honorable Minister, can we have concurrence that when I say thank you, Minister, that's indicative that I'm satisfied with your response, so that I don't appear disrespectful when you, so that I manage my 15 minutes well, please.
Okay, all right.
We have concurrence.
Okay, I hope you'd really be satisfied with my response, and you're not just cutting me. Yeah,
you know,
I know. Thank you. Yeah,
I have integrity on that level.
Of course, you have.
Chair, I'm going to trust you now because I don't have my minutes starting. Okay, Minister. So one of the board members on my right here read earlier a statement purporting that you stated that the board has not done anything wrong that warrants any sanction. Do you agree that you have made such a statement formally?
Yes, that statement was made in our application for self-review before the court. which was made sometime late last year. And I think the statement was repeated, consistent to that submission which was made before the court.
So what's your reason for sanctioning them?
Well, it was a completely different board when that statement was made. It was a board that didn't have some of the resignations that it had. And I think a few other points which I've consistently mentioned in this meeting. But importantly, it was a different board at the time when that statement was made.
That's very interesting because now, because I hear the statement for the first time, the impression was that it's in reference to the current board. So you are saying it's not?
Oh, no. I'm saying the current board was in a different form when that statement was made. So they had a substantive chairperson, and so on and so forth. So it was, initially before all of the resignation and before some of the points which I've
all right.
mentioned of.
Thank you, Minister. So are you then saying in its now form, as we said here, they are guilty of wrongdoing and they require sanctioning?
I think it's important, and I've reiterated this point, that the board, both as individuals and as a collective, because I think we tend to view this as though it is punitive. It's actually not, and that the intention was that with all the integrity, with all the competence, although Honorable How does not agree, and all their expertise combined, that's what the statement was intended for. But it does not take away, Honorable Sauls, it does not take away that certain things were not there in order for it to be seen collectively, the team to be seen collectively as a board.
I guess what I'm trying to get at is, does that statement apply to the current board as we sit here now?
Well, that's why I went on to appoint an administrator, because that statement, which was made at that time, to a board that was constituted in that way, did not apply on the day when I took the decision to put.
So now they are guilty of wrongdoing and require sanctioning.
Well, I think those are your.
Well, it's the words that you used for the previous in the opposite. So I'm just trying to establish: do you maintain that for this current form of board or not? The same words that you used, because I'm not using my own words. So it's not strong words from me, it's strong words from you, but just now the opposite. Does it apply to them today or not?
Yeah, the board as it existed or as it was on the 4th of May required me to take action, and action that I took. And on the 4th of May, I didn't use the word wrongdoing and sanction. I said what are the reasons that led to that decision to be taken.
Okay. What specifically, is there anything specifically wrong? Was there anything specifically wrong in the recruitment process and appointing process of the CEO by the board?
Not that I know of. Personally, I wasn't involved in the recruitment and appointment process of the board. Safe to say the concerns raised by the interim chair, that he's worried that the board may go ahead to make an appointment without having concluded their own processes.
Is it true that you gave an audit directive to the board with 2 deadline dates? You want them to deal with the audit issues, and you gave them 2 dates to come back to you with progress. Is that true?
Yes.
Which was those dates?
I think the first date was, if I'm not mistaken, the end of April, and the second date was the end of May. but I stand to be corrected. But I
So-
think it was more or less, yes.
Can the board members confirm?
We agree. We agree on that.
You have concurrence. You have concurrence. So it's the 30th of April and the 31st of May.
Yeah.
All right. Did they meet the first deadline?
Well, the first deadline, which was on the 30th of April, the board was not constituted in the manner in which, when I issued the instruction or the directive, that the board was, so it was a completely different board, that
Okay,
wrote
Minister.
to me on the 30th. So
Sorry, Minister.
Yeah.
Did they submit
Yeah.
on that deadline as you prescribed on the 30th of April?
Well, on the 30th of April, the 7 members of the board who were remaining wrote to me, presenting to me a response to the deadline, which they had, presented to, which I had asked for on that day.
Did they meet the deadline?
It was present, but in my view, they were not a properly constituted board. So although the correspondence was sent to me on the 30th of April, I do not believe, as I stand here, that they were a properly constituted board.
Well, we're not dealing with how they were constituted.
Well, I think it's important because,
But we now know that they 7.
Okay.
You've given them a directive
Yeah.
to deal with. What is important of that question is the fact that you've got 2 reasons why you're putting them under administration, one of which is the audit issue and progress on that. Now I'm asking, you then gave them 2 deadlines. One, 30 April, give me progress on this issue
Yeah.
that you are having as one of your reasons. They then, I want to now know, you've given 2 dates. 30th April, did they comply to that deadline?
No, I don't think they complied with that deadline.
So they didn't submit you their progress on the issue by the 30th of April?
Well, a letter was sent to me by the 7 remaining members of the board, talking to the directives that I'd issued to them.
So then they complied, Minister. Then you have the 31st of May, which has not arrived yet. Your number one basis for putting them under administration, you give them 2 deadlines. They submit on the first deadline. They are yet to submit progress on that number one issue. That date, 31st May, is still to come. You put them under administration as one of those reasons. What is the reason for doing that when the deadline is still coming?
I think the point that I've made, and quite consistently, is that I did not believe that the board, as it remained after those resignations, would have been able to competently meet up with the directives that I've issued to them. And that's why I took the decision that I took.
It still remains that they are complying. There's a deadline due. You put them under administration before that deadline. Your second reason is the composition of the board. Advocate, can the board legally function with 7 members? We've got to go quickly now because can the board function legally with 7 members?
Yes and no.
Quickly give the yes or no.
I said yes and no.
Yes, but why yes, why no? Quickly.
They have been operating whilst there were 7. And the no part comes from the fact that out of 18 members, there are only 7 of those members that are in existence.
Yes, but with 7 members,
Yeah.
legally can they function?
No.
They don't have quorum according to the Act. How many members should there be in total? 13.
Out of the 13,
Yes, the majority would be 7.
yes.
That means that they have a quorum.
In the context of a quorum, we would be looking at who is represented in the 7.
Yes,
And-
so the ones that's not there is the financial part, too, and then also from the Minister of Finance part. But if you'll have the student, you'll have the governance, so those categories are covered in that 7. So I understand that. The point is, as 7, can the board function? Advocate.
Why I said yes and no was in the context of saying out of the 7, you do not have any financial expertise, you do not have the ministerial appointee from the department, the minister from
Yeah.
finance.
Thanks,
Yes.
thanks, Advocate. I would have read you something that says that that vacant positions does not mean that they shouldn't function. It's actually law. But let's entertain the concept. Out of that 6, how many out of that 6 should be appointed by the minister? The remaining 6. How many should be appointed by the minister in terms of the Act?
Out of the 6, minister would have appointed, can I just check?
Okay, just because of my time, let's do this. The 2 that, Advocate, the 2 that you are referring to, that is still required, which makes you say no, that 2, that finance 2, who must appoint them?
It's the 2 ministers.
So, if the minister does not appoint them, how do you hold the board responsible for something that the minister has to do?
If you recall, Honorable Souls, the minister is before court, and for him to have gone ahead and put in new members, it would mean that he disregard that application that he had lodged in court.
So it's the sub judice issue.
I would imagine so.
Should he then not apply consistency and use sub judice before he puts them under administration?
It would have been considered. However, sub judice, even from the legal opinion that we received, is not restrictive. And I would imagine when there are new facts that appear, you would want to look at those new facts. You cannot ignore them simply because.
So you are saying that the minister, just now you must confirm with me, Advocate, the minister has done the correct thing legally to, on the one hand, not appoint 2 appointees that the minister requires for him to consider the board properly constituted. He refuses to put those 2 members because of the sub judice rule. Then, in the same breath, puts them under administration because those 2 members are not there.
I do not want to speak on behalf of the minister.
We'll go there, but we're dealing with the legal issue. What do you legally... That's not the chair, so ignore that one. That's the... We want to legally, before I go to the ministers, my last, because now my time is up, we need to establish, do you see the inconsistency?
If you believe that there's inconsistency.
No, forget my belief, Advocate. Just based on the law, give us the advice on the law. The minister is correctly using the sub judice rule to say, I will not appoint these two until the self-review is finished. We understand. Then he says, I'm going to put you under administration because these two people are not appointed.
You are referring to two separate, distinct processes.
Explain.
Yes. And the first one of the self-review, it is the minister himself who is taking his decision to court. That with the time remember it's him now, at the time this board was appointed, there were some irregularities and he would want the court to make a determination
I understand that.
On that.
I fully understand that. I fully understand that. He's taking that under self-review. But he's using that as a reason not to appoint the two members needed for the minister to look at the board as properly constituted. These are not two separate issues. They are two separate legal processes, but not the one affects the other. So, okay, Minister, rather because, okay, Minister, as I conclude then, Minister, we've seen that the first reason that you've given for administration, there was 2 deadlines set. You went ahead with administration before the deadline. Your second reason is the constitution of the board. But on the one hand, there are the two members, or seats at least, that the Act empowers you to appoint. You use the sub judice rule, on the one hand, not to appoint them. You then put the board or NSFAS under administration because those 2 members are not there plus the others. They are not properly constituted because of an act on your part that they don't have control over. So to protect your decision on the one hand, you use sub judice, but they don't have the same protection. You use that as a reason to put them under administration. Do you see that as an inconsistency?
No, I don't see that as an inconsistency. And maybe can I just explain this? Well, our time is done, but just I think, Chairperson, with your indulgence. So on the 20th of February, 12 members were appointed to the board. And those were without the National Treasury and also without the 3 student representatives. And the student representatives, 2 student representatives were later co-opted into the board, making the board 14. And remember that I think there's proviso that the board can go up to 18, but also the composition of the board is not just constituencies, it's also based on, on expertise. But the point that I'm trying to say is that, the external legal advice that Advocate Kuta referred to earlier on also implored on us that further actions which were taken, for instance, to co-opt the student members in order to correct the composition of the board at the time, was actually inappropriate or improper. And that's why we approached the court to set aside this decision. Now, based on that, not based on any other thing, based on that, when the board wrote to me asking me that I should, fill up the vacancies, I indicated to them that we have this legal advice which says that I cannot augment, the board or fill in vacancies, and so on and so forth, because that matter is before the courts to determine, in terms of its composition. Now, that was a board that, we took to the Pretoria High Court for self-review. Now, the board that I am now that I have dissolved on the 4th of May, only had 7 of those 14 members remaining. And it was not just about the composition of the board. I think it had to do with a whole range of other things. Now, the parliamentarians who adopted the NSFAS Act understood that the body itself would require a particular set of expertise and constituencies to constitute the entirety of the board for it to function properly. And as at 4th of May, I did not believe that the board, as it stood on that particular day, fulfilled those legislative requirements. And I think that that's the, I do not believe that there was a contradiction. I believe that we need to separate the two matters. They may seem to both matters be related. I think that they are actually separate.
Okay. Advocate Kuda, how do you determine the quorum of a board meeting of NSFAS?
Chair, I've checked the Act. The Act does not refer to any quorum. And I think it's one of the gaps that we've identified. That's why we are smiling.
So the answer is that the Act is silent. Okay.
Chair?
Yes. Your time had long expired, no?
I'm seeking clarity on what you just said.
No, I'm still making the point that can be true, Advocate Kuta, because actually go to section 13, subsection 3 of the Act. Trying to scroll, my laptop just decided to. I can't scroll, but I wanted to read to you what it says. I don't know why it's doing this. Must I tell you what it says, Advocate Kuta? It says, the board may make rules relating to the procedured meetings of the board and its committees, including the quorum of such meetings, and any other matter necessary or expedient for the performance of the functions of the board or its committees. What is your understanding of what this section 13, subsection 3 says?
My understanding, Chair, is that the Act, as it is, does not say what the quorum is. It talks about the board making rules, meaning how much the quorum would be in the rules, not in the Act.
Yes.
Yes.
Now, so in order for you to know what is the quorum, if you say the board does not meet quorum, you will need to know what is the quorum that they set for themselves as a board. Now, the argument is that you are saying, legally, Honorable Souls ask you, legally you are saying this board did not meet the legal scrutiny to be a board. And you said it's because they don't meet quorum. So where did you get this quorum of this board, this particular one, when the Act itself says you should have asked them to give you what was their agreed quorum?
I mean, the board would have given us the rules which determine what their quorum is.
Yes. Because that's what the Act says. Section
Yes.
13, subsection 3
Yes.
says they will decide
Yes.
what the quorum is. I don't agree with such an act myself because it doesn't make sense in my view. But it's there. It's an act which I've said I don't agree with it. Now this act says there's no rule if you have not gotten it from the board or the board secretary that says 7 out of 18 does not meet quorum, because now that's an assumption. So you have based your argument on assumption because you don't know the rules. It says they must determine their own rules. And then, so you agree that the assumption that says 7 out of 18 does not meet quorum is based on something outside of what the Act says.
I'm not basing it on what outside what the Act says. I accept, Chair, that the rules that the board would be using to determine the quorum, I have not checked them.
Okay.
Let me accept that.
Okay.
So that we don't go further.
Okay, so the assumption that 7 out of 18 did not meet quorum is not true, because you don't know. It might be true, but it's not, you can't verify that you based it on the rules that we're supposed to follow. Let me go quickly to the second one. The charter, the board charter, and I said, as I send you the charter, I have it. So let me tell you what the charter says about the quorum.
Sorry, Chair. You can allow me to come back, or?
On the quorum?
Yeah, you said you want to finish the point.
Yes. You wanted clarity?
Yes.
On my question?
You wanted to finish the point first, yes.
Okay, what is the clarity?
Do we now, for the record, accept from the side of the minister that the board can legally make and function with 7 members?
Can I read what the charter says?
Yeah, no, let's hear. You want to read what, 17.2? Or what do you want
Yes.
to? Yes, let's read that one.
Okay.
No, read that one. You want to answer him?
17.2. Yes.
Yeah, you can go there.
A majority of the member present in person or by using any technology will constitute a quorum, provided that at least 3 members of the executive committee, as contemplated in Section 10 of the NSFAS Act, is present. So for me, the 3 members of the executive committee would be the determining factor for the quorum to be legitimate.
And then in the 7 members, there were no 3 executive committee members.
I can still check that.
Yeah, so you see, that's why I was saying, I'll give you just now.
Yeah.
I'm going to give you. That's what I was saying. You can't say there's no quorum when you've not determined these things. You must first determine that this is what the charter says, this is what the Act says. And because if you say there was no quorum, you are, that there was no quorum. And now, that's why I was taking you to 17.2 to tell you that there's 2 determining factors for quorum. And the other one here is that one of EXCO. It says, even if you can be 15 in the meeting, if there's no at least 3 EXCO members, that meeting does not form quorum. So quorum is not a matter of having Yeah, they are determining factors, and that's what you should have done to get from the EXCO, from the board members to say, we are making a determination that you don't pass the test of time as far as you being a legal entity is concerned, or legal structure, because you don't meet the legal issues. So you have said they don't form quorum or meet quorum, and you have not satisfied what the NSFAS Act 13.3 and 17.2 of the Charter suggests or tells you, defines as a determining test for what a quorum is. So that's where the problem is. I think you can see. Now, I'm going to, no, maybe let me give you an honorable soul so that you ask that particular, the final question before I go to Honorable Zondo and Honorable Mayman on the line.
I think your direction is brilliant, Chair. So maybe I should first allow you to do what you wanted to do with the board members and get that clarity, and then I come, if it's okay with you.
Okay, your time is up. You want to come again?
Just based on the question you've just
Okay.
posed to me, I appreciate your benevolence.
Okay. I don't know what is the meaning of that word, but
We shall get concurrence.
oh, okay. Dr. Mgadi.
Thank you, Chair. Just for record, 3 board members that are sitting here are also members of EXCO.
In addition, Chair, the issue of a quorum is not something that we took lightly. In fact, as soon as we received the resignations we received, the company secretary was very reluctant as a custodian of processes and the law and an advisor to the board to have the meeting of the board to proceed with 7 members. He advised that the best we could do under circumstances was to get a legal opinion on that, and the board did authorize the company secretary to secure a legal opinion. The legal opinion came indicating that the board is duly correct, and this is an advice we also gave to the minister when he sought representations from us. We did tell the minister that the board is duly correct. Thank you, Chair.
Honorable Souls.
Can the board legally function and execute its duties in terms of the Act by being 7 members?
You're asking who?
The Honourable Minister.
Minister.
Yeah. Well, I think I've responded to that question to indicate that at the time when I wrote to the board, I did not, I was not of the view that the board is functional, or that I think there is actually a particular wording in the Act that speaks to the functionality of the board, and especially in relation to the tasks that was at hand, and I think it was on the basis of that that I went on to take the decision that I took.
Chair, I want to come to Advocate. Advocate? Oh, yes. Now that we've traveled this part of explaining or trying to find what is a quorum, 3 EXCO, Board Charter, NSFAS Act, according to your legal understanding, if after you also do your own reading, which I believe you are doing now, you come to the understanding that we have, that the board had reached, the board was correct according to the Act and the Board Charter, would you agree that decisions which are taken by a correct board would actually be both lawful and binding if those decisions were taken before the board was placed under administration?
Yes. I'm saying yes.
Honorable Zondo, are you there?
He's not here, Chair. He's not here. We can pass.
Okay. Honorable Maimela.
Thank you very much, Chair. I am here.
Thank you.
I see the acting chair that I'm contesting with is ready or eager for the meeting to be finished.
No,
He's tired now.
there's no
Thank
acting
you very much
chair.
for the
There's
opportunity.
only one chair. Honorable Maimela, yeah, your network, I wanted to say your network is a bit weak. If it persists, I'll ask you to close the video just so that we improve the bandwidth. But it was hugging a bit, so let's hope that it will hold now.
Okay, thank you very much, Chair. I can hear you properly, but I know it will persist because I'm at Acacia. Thank you very much, Chair. Chair, for me, there's three bottom lines that I want to get responses on. The first bottom line, Minister, is that as a former beneficiary of NSFAS and for students who are sitting at home now, they want to understand how does this conversation affect them. Will they still receive their funding? Prospective students who are going to be applying in September want to understand if their applications for funding will be considered, if the accommodation of the current students will be paid. So for me, I really want to get an assurance from yourself and the team from NSFAS, given the fact that the GTEC report raises a whole lot of issues. 8,000 deceased students who are on the beneficiary list and they shouldn't be there. Non-qualifying students who are appearing on the beneficiary list as qualifying students, and qualifying beneficiaries that are not being approved on the beneficiary list. And that for me is the crux of the issue. I'm extremely worried about that aspect because it speaks to the plight of students at home who are watching us to say, how does all this affect me as a student at home? So I want to get assurance firstly. If these issues that you've raised in the presentation, if there's any plan, firstly from yourself to resolve those issues, then I'll come back to the second bottom line. Thanks.
Thank you very much, Honorable Maimela. I think in terms of that particular bottom line, I think we can confirm that the student allowances will not be affected. So that is the transport and tuition and all of the allowances that are due to students. And secondly, that the process for the applications for the academic year 2027 will also not be affected, that process will have to proceed quite smoothly, and that we will, as we did this year, I think properly prepare for the new academic year with all the lessons that we've learned and all the work that needs to be done. And in fact, that experience for students have to be much better than it has been. And I think that's what we are all aspiring for as the ministry, as the department, but also the administrator and the NSFAS administration, that no one should be affected by this and no one will be affected by this. So that's in terms of the bottom line. I think that's the guarantee that we would like to give. As things stand now, as I appear here, something else can happen next week, and I'll be quoted here as having said this. But I think importantly, students should be confident that none of them will be affected by this, and in fact, we're trying to improve the service.
Thank you very much, Honourable Minister. I do want you to then commit that you're going to give us a comprehensive report on how you are resolving these three issues of deceased students on your beneficiary list, unqualifying students, and qualifying students who don't appear. The second bottom line for me, Chair, is that the Minister and the Department must understand that as Parliament, we have a responsibility to ensure that the Executive adheres to the lawful framework established and that the executive decisions that they take are in a structured, informed, transparent, and accountable manner. And as a result, that's why we're asking these difficult questions. And I want to continue on the line of other members to ask these difficult questions. The first one, Chair, goes to us as members of Parliament. And this question is prompted by the fact that there is an allegation that is made by one of the former board members saying that the other former board members, who is no longer a board member because they resigned, called them and make inferences to the minister instructing who should be appointed as a CEO. Now, I want to ask the invitation status of former board members. Did we invite former board members who were only dissolved, or did we invite all former board members, inclusive of those who had resigned? Because if Ms. Karabo, because that is the specific board member that is mentioned, was here, I would have really wanted to hear her side of the story in terms of the allegations that are made, because they're quite damning. So I just wanted to check, Chair, if we did invite them, and how do we get to a point where we are able to hear the side of the story of this specific board member?
No, thank you very much, Honorable Maimela. Just to remind members that the decision to bring in former board members was taken by yourselves in the committee initially on the 6th and on the 20th when we met. And I asked members who must, when you suggested, and the meeting resolved that we must invite the dissolved members of the board. So the initial invite that went to the dissolved members of the board. And then early yesterday, I then asked Anela to invite the two members who resigned last, just to get a clearer picture of the issues. We did get a response from Karabo Mohale, who indicated that should not be able to participate meaningfully because of the late arrival of the invite to come and participate in the meeting. But that invite that was sent yesterday, it was just me thinking that to get a comprehensive picture, I must invite them. But your meeting of the 6th and the 20th had resolved that we must bring in the dissolved members of the board, which were the people that were invited. Thanks.
Thank you very much, Chair, for that response. I think it suffices, and thank you for your foresight in trying to invite the other members that were not part of the dissolved members, because, of course, the committee wouldn't have anticipated that they would be mentioned in the discussions. As a result, we wouldn't have seen the importance of inviting them. But I think now it is important, and as a committee, perhaps we might have to reflect on how do we get Honorable Mohale to utilize the same principle we've utilized with these board members, that they should be here in the same breath with the department so that they're able to raise their own voice and we can hear their side of the story. So we should also endeavor to hear the side of the story of Honorable Mohale. That's my own point, but I really appreciate your foresight, Chair. And now, Chair, since we've heard about the composition of the board, that actually the Act speaks about 13 and all the other inclusions are actually counted within the 13 in terms of the Act. So the inclusion of the representative from finance, from the department, it's actually within the 13 in terms of the Act. The 4 comes in as a co-option. Now, my question is to the department, given that they cite the ordinal rule, Minister, wouldn't it have been prudent that you have your own representation and finance has representations in the board, that when you say it is irregularly appointed, but its decision still stands. So they are going to take decisions on money, they're going to take decisions on students, they're going to take decisions on how students are going to be financed. Wouldn't you want representation, and wouldn't finance feel that it is prudent to have representation in such a board, even though there is a self-declaration matter before the court? I just...
I think just to indicate that, you know, by the time we before we approached the court for the self-declaration, I think the representative from the Department of Higher Education was still a member of the board. I hope I'm right about this, and that I'd also had a discussion with the Minister of Finance, you know, for them to fill up that slot, because that slot was not filled up in February on 20th February, when this board was when the board we're talking about was you know, was appointed. So there were you know, intentions of doing that, or of ensuring that the board is properly constituted. But I think the trick becomes the you know, the legal advice that suggests that if we make any addition, you know, to the board, so you know, that will actually be acting contrary to the you know, to the matter that we've already approached the court about, which is asking for the court to declare that decision, to set that decision set aside. So that's the quagmire which we faced you know, ourselves in, which is the response which I furnished to the interim chairperson of the board when he you know, requested that we do fill up the vacancy. So it's not something we took lightly, because the operations of the board, and I think you can see consistent with my action, you know, the proper operations of the board, I think you know, for us was important.
Okay, thank you very much, Minister. I think for me what is important is the fact that you saw it prudent for representation, because if you look at the NSFAS board and the composition, representation is at the center of the board. So the intent of the lawmakers was that students must be represented, you must be represented, and as well as Treasury must be represented. And the fact that you saw it prudent for you to be represented, for me, that's okay. I want to then understand who sought the legal opinion and why. And I want to hear this from the legal team. Who sought the legal opinion and why was the legal opinion sought?
Thank you, ma'am. The legal department was approached by the office of the minister to provide a legal opinion on this matter of the establishment of the board. And we then, through the state attorney, sought an external legal opinion from a senior counsel, as internally we were not in a position to do the legal opinion as quickly as it was expected. So the legal opinion...
Apologies, Chair, because my time is running out. So why, what were the reasons of the minister to seek the legal opinion at the time?
As I said, there were inquiries from especially student organizations who, you know, were aggrieved about the, you know, representation. And I think over and above that, they themselves had sought legal opinion which which I was presented with as part of the list of concerns that were raised around the board, and that's why we then asked formally and officially within the department that we get a second opinion on these issues.
Okay, thank you. So the second question I want to know is that, so the excluded bodies, meaning the student part, the student organization or the student representative, because I understand with the department and the finance, was that ever included? Because you alluded earlier that the former minister tried to add, and that was also deemed as irregular. So were students represented in this current board that we're speaking about?
Yes, as a result of the one addition from, as a ministerial decision, and the other one, I think, as a result of the decision of the board, if I'm not mistaken. Yeah.
Okay, I think that's fine. So now let's go to the issues that are actually burning. So I want to understand the insinuation or the allegations here before us seek to link your dissolution of the board. They link that with the appointment of the CEO process. So there seemed to be an established link that you actually dissolved the board because there were disagreements within the board on who should be a CEO, and somehow there is allegations that you also had interest in who must become a CEO. As a result, you tried to influence some members of the board to either resign, to influence the process, and if they couldn't, they should then resign. So I want to hear and I want to establish if this is true, because for me that's very important.
Yeah,
I want to start with an issue that is established here. There is an established fact that there were two advertisement processes where the board firstly said there is no enough representation of female candidates, and as a result we should go out on advertisement again to get more representations. Were you part or were you informed of these two processes? Were you ever part? I know you answered something towards that point, but I want to make sure I heard you correctly. Were you part of this process, or were you aware of this process? Did you ever influence that process of the board's decision to go to advertisement again?
No, I was not part of the board's decision to re-advertise. I did not issue such an instruction. The only time when I issued an instruction was when the board was asking for my concurrence with regards to the extension of the acting CEO, which was outside of the 12-month period. And so the undertaking from the interim chairperson of the board was that, yes, we will proceed with, the acting CEO, and then we'll also start with the process or, fast-track the process of the appointment of the substantive CEO. So I was not involved in any of those, and I was not party to. And I think any other thing is basically innuendo and, suspicion and so on and so forth.
Okay, thank you, Minister. Second one, I want to ask on this process. So deal with shortlisting and, of course, interview process, and finally a recommendation to the board, because the board then must make an appointment. Now, my question is, do you know who, or did you know who the board finally who the panel, the candidates which the panel finally recommended to the board? Did you know? And also, did you actually have an idea of the candidates that appeared before the panel for interviews, for example? Because then that will substantiate if you knew why you would have an interest or preference, because you would know who appeared before the panel.
Well, I only made aware of all of this when the stories broke in the news. They were all over the Sunday newspapers. One of the weekends. That's when I knew with everyone else as to what were the process. This was never a subject of discussion between myself and the board members, you know, and I never sought to interfere with, you know, with that process.
Okay, Chair, I want to know now from the board members, the former board members. One of the former board members, I think it's Mr. Ramashia, says the meeting was strange or was weird. I'm using now Gen Z's language, weird. And it was instructive. Now, I want to know, because when you say a meeting was instructive, it means there is a set of instructions that were meted out in the meeting of the 13th of April. Now, I want to know the specific instructions that the minister issued to the board on that day, because the meeting was instructive and that was how it was characterized. So we then need to understand the specific instructions that were actually issued by the minister in that meeting. I just know of, I heard when the Mr. Ramashia said there was an issue, an instruction on the acting chair, which was Ms. Mohale. But what were the other instructions? So was that the only instruction in that meeting, or were there other instructions issued by the minister?
I did not get your point about the instruction relating to Ms. Mohale. I'm not sure if it is something that I would have said, but be that as it may be, the specific instruction that I'd made reference to was the instruction not to proceed with the appointment of the Chief Executive Officer until such a time that the minister comes back to us in a period which was rounded up to close 2 weeks. He actually specified a particular Friday. I think I had made note of the particular date, but that is the specific instruction that I've referred to. If you may refresh your question relating to Ms. Mohale, I don't remember any instruction in that regard.
Okay, just to refresh our memory, if I got it wrong, Chair, you'll assist me. I remember the Mr. Ramashia specifically saying that the minister's meeting was instructive because it instructed them to say Ms. Mohale was the acting chair. And Mr. Ramashia even said to us that was not the responsibility of the minister. So that's the reference I was making. If I got it wrong, I apologize, Chair, but I think the other instruction that I got, because now I have clarity on the other instruction that was given to the to the board, I'm fine with it. But that was if I'm wrong, Chair, please clarify that I'm wrong so that I apologize.
Yeah, no, thank you very much. I'm trying to think of the word that he said. In fact, I think a member here, I can't remember who said, it was Honorable Khabo, who said it means the minister imposed the name of Karabo as the deputy chair, and the advocate there said no, that's not the case. It's what the minister had said in the meeting and not instructed them that she will be the deputy chair or imposed her. I think that was the response there. So he did, in fact, when it was put to him earlier on, he did indicate that that was not the case.
Okay, thank you very much. Because
and the minister agrees. The minister says, and he agrees with them. So
finally, we get the concurrence.
Finally, there is an agreement.
Yeah, we got a concurrence at last.
Okay, thank you very much, Chair. The third bottom line for me, Minister, is now how do we move forward from where we are now? And Chair, this also goes to us as a portfolio committee, because there is certain facts that we've established out of this engagement with both the former board members and the department. And for me, I would really want us as a portfolio committee to reflect on these facts that we've established and those that require, and that's my proposal to the portfolio committee, that perhaps we need an in-committee reflection on how then do we want to move forward so that we're able to establish what are facts that we established, what is it that we need more information on, and we get that information. But the third for me is this issue, Honorable Minister, and is what I asked earlier. Is there a link between your dissolution of the board and the appointment process of the CEO? So finally answer that question, because that's a perception that we all have, that is out there, that there is a link between the timing of the dissolution of the board comes at the time where the board must finalize the process of appointment of CEO, and seemingly there are issues with the names that are flying around and what is out there. So you need to take us into confidence if there is such a link. If it exists, what is the nature of that link? If it doesn't exist, how then do we move from here? Because the board did not finalize the process of appointing a CEO, and you said to us, AG said you must finalize that process.
Yeah, there is no link as I think it's been suggested. The one process was the process of the of the board, and the other process was the process that I, as minister, was responsible for in terms of the proper constitution and functioning of the board. And in no way in any of my decision did I seek to influence that a particular individual should be appointed as the CEO of the of the NSFAS to the board.
Intervention, Chair, is that, Minister, I agree with the sentiments of the members on the platform. And I agree with these sentiments on the basis of what the Act intended, the NSFAS Act intended. You know, the Act intended representation of different stakeholders in the board of NSFAS so that all stakeholders can have a voice on how we actually administer the funds of NSFAS. So when you bring an administrator instead of a board, it's one person. So it's one person's thinking, it's one person's discretion. There is less oversight from your side because when there is a board, you've got as a department a person there that is safeguarding the interest and the vision of the department, as opposed to when you just have one person as an administrator. And for me, Minister, I really do. Then there is no student's voice. So the administrators themselves, Honorable Khakhawa at some stage said it's a god, you know. So there's no student voice. Students can't say because there's an administrator, but in the board, they then have a voice. They've got a standing. They're able to be represented. For me, that's a serious crisis. It's a serious issue. And for me, I want to then put it to you that it's not a position we wish we could be at as a portfolio committee and yourself also as a department, and that indeed it is very difficult for us to believe that this administration process will actually bear results when the other two administration processes did not. So please give us assurance. But beyond that, Chair, my final submission is that the committee needs to reflect on how then do we move forward in an in-committee sort of way. I will leave it there, Chair. Thank you very much.
I really appreciate Honorable Imela. You had your hand up.
So if, without disrupting the minister, because the point that I raised, okay, the minister says I can go ahead, with your permission, Chair. It emanates from a question the member was asked as a question relating to the options that were available for the minister in terms of the legal opinion that the minister referred to. And I think if attention is given to Section F of that legal advice, particularly from paragraph 101 up to 104, you would understand that the legal opinion itself did not preclude the minister from filling the vacancies. as it would have been canvassed. In fact, the only thing the legal advice said was that was to raise a difficulty because at the time there was only one vacancy. So when we responded to the minister's self-review application, what we said in our answering affidavit was to lay practical options which would have been available at the face of the minister, and it's in line with what the legal advice would have advised at that time, that co-option is a possibility available for the minister. It was at the time only limited by the fact that there was only one vacancy. But at the time when we exchanged papers and advised the minister, there were sufficient vacancies on the board for the minister to remedy a crisis that would have emanated as a result of improper constitution of the board. Thanks. I wanted to clarify it in the context of the opinion.
Okay, thank you. Oh, Dr. Mkat.
Thank you, Chair. Also, just to clarify, the board subsequently said, after it had seek a legal opinion, whether it is correct and whether it can make decisions. The board sets approved fourth quarter reports, and it then concluded on the matter of the appointment of the CEO. And a letter was sent to the minister. So it is not true that the minister would have found out on the news. We sent, as the board, our appointment of the CEO. We then requested the minister for concurrence. It is then on that Monday, after we would have given that, sent that letter to the minister, that then the dissolvement that we saw on TV arose.
Okay. Honorable Maimela.
No, Chair, I wanted to just get clarity on this narrative by the former board members. So they sent a report of the panel to the minister, or was it a report of the board? Because remember, my question was on the panel. Remember, the board, when it said, and the minister was saying, wait, because that's what they said. The minister said, wait on the process. The minister was saying the panel had not concluded. So I want to know if they sent the recommendations of the panel to the minister or the recommendations of the board. Because the board would have said and considered the recommendations of the panel and then send them to the minister. I think that would be the flow. So I just wanted to get clarity on that one.
Thank you. I think what we sent was a board decision that was final to the minister. What we had been sending to the minister is reports updating the minister on the developments of the recruitment process for this last 3 months. So, minister would have been aware of what is happening in the recruitment process, and of course, we can show those reports.
Are you answered, Honorable Maimela?
Yes, Chair, I've answered that. So the minister, but I also want the minister to come in. So it's the final recommendation of the board. So whatever they would have sent to the minister would have one name. Because obviously if you speak about the panel will show the names of people they interviewed, the scores and everything. So what the minister received is one name. So I just want to get a reflection from the minister on this question.
Yes, so what the board sent me on the 30th of April was what they said was their decision in terms of the appointment of the CEO, which was one name.
Honorable Lonzi.
Chair, when Honorable Maimela had asked the minister about the recruitment process, and I just wanted to clarify because maybe I misheard him. His response suggested that he actually saw these things in the media and that he was not aware of this until the final day, which would be 30th April, and that the only thing that he would have been aware of is a complaint from the interim chair of the board. Now, a member of the board is saying they would have been sending reports to the minister, almost giving an update every step of the way about the recruitment process. So those are conflicting versions. But I don't want to suggest anything than to give maybe the minister another opportunity to clarify that point.
So the point to clarify, Minister, is that is it true that you got the regular updates from on the recruitment process that the board was busy with?
Look, I mean, as to the details of the updates, I'll have to I'll have to check what is it that the board has shared with me and what the board hasn't shared with me. But what I said and confirmed was that the recruitment and the appointment of the CEO was a board process. And they may have as well, I think, probably updated me on how far they are since I'd given them a deadline. And in any way, as I indicated, in terms of my discussion with the interim chair, it was around his consent on the entirety of the recruitment process, which resulted in the meeting of the 13th of May. As to the intricacies of who has been shortlisted, who has been interviewed, who is being considered, I considered those fully, the process of the board, and I didn't think that it was important for me to, to be drawn into that particular process.
Yeah, Honorable Nguban.
Chair, with the hearing now that the board member said he heard it on TV that they are now being dissolved, was the Section 17 of a consultation process by the minister with the board of dissolving them canvassed enough of the reasons for the dissolvement? Because I hear they said they saw it on TV. So where that Section 17 complied?
I think I indicated, Honorable Ngubani, in our presentation that, in our view, we did comply with that. We did comply with the entire process.
Honorable Sols.
Chair, I just want to check if the minister believes that he's got the power to revoke the decision of the board of the CEO choice.
Look, you can only revoke a decision which you have powers to institute. And in this case, if I don't have powers to appoint the CEO, I therefore do not have powers to disappoint the CEO. And as I've repeatedly said, that it is the decision of the board, and that the role of the two ministers of higher education and of finance is concurrence in terms of the terms and condition of their employment.
Let's or closer to the closing of our meeting. A few things that I think we must note, Minister, that for a government ministry, let's convene meetings better moving forward. Let's have when we call our entities, let's document it so that it's able to also protect you tomorrow. That this is what I went to discuss with the entity, so that doesn't create this narrative that you went to have a secret meeting to give them an illegal opinion or legal instruction, because that comes from these things of us not being able to indicate this was the intention of the meeting. In fact, from what I'm hearing you to be saying is that there was no bad intent in meeting the board at that time. That you said to them in the meeting that was, or you're going to say to them that was going to be illegal. We could have even kept their phones in the meeting, because it was a frank engagement with the board to say, listen, I'm receiving challenges, or I'm receiving potential problems that are coming from your chair, that you want to finalize this thing without finalizing, or you want to appoint the CEO without finalizing certain steps in the recruitment process. Corporate governance, King 4, King 5 speaks about you doing this things this way. And I don't think there was a personal, I don't see a bad intention there. But when you have taken people's phones and there's no written agenda, it then creates this thinking from some people that indeed this was what was going to happen. So maybe next time let's convene meetings a bit better there. Secondly, I think this entity called NSFAS is an extremely important entity. We want that entity to perform at its maximum. So it must perform at its maximum potential so that it's able to respond to what government has promised our people. We have promised that we'll take these kids to school, we'll put them in proper accommodation. We promise that we'll give them allowances. This NSFAS should be able to deliver those things, because if it does not, it creates an impression that us as politicians, we go to these institutions, we go to communities, we lobby people to vote for us, we promise them X, Y, and Z, and then we're unable to do so. So what do we do with NSFAS there? Central to it should be, it must be student-centric. It must resolve problems of our people. We don't want a situation where we're unable to pay accommodation providers. And I've said this many times. When you don't pay accommodation providers and they evict these kids, they evict them, let me tell you, they evict them one at night when they know that they will be very vulnerable, and they evict them maybe on Saturday evening or during exams. So they choose a specific time. So when you don't pay, this is what you are subjecting these young students into. Many of them who are females don't have anybody else to give them even 30 rands to call their parents. They will speak to them on WhatsApp. And if their parents come from the township I come from, when there's no electricity, there's no network. So it means WhatsApp does not go through. So there's no, literally you are sending these girls, these young girls who are students, into the hands of vultures who would want to take advantage. I said vultures. I saw an opinion piece of the former deputy president of the Youth League last week. He said in Parliament, vultures are circling in. And I decided to use that word. It was purely by mistake, I'm not meaning, there was no intention. There was no malice to use there was no intention, a bad intent to use the language of the minister, at least So I think I'm sold with your idea, Honorable Maimela, that as the committee, we will need to meet on our own to have a way forward on these issues. But I hope the department now can see what we've been telling you about the acts. This Higher Education Act, this NSFAS Act, the CET Act, the Skills Development Act, they are literally they are going to create more mess for us. It's something that must be done, and Minister, I think maybe you must nudge them so that we are able to get to the end. We are able to bring these proposals to Parliament so that we can start our own process of dealing with them ourselves. When we say we need changes in these acts, we want to strengthen them so much that we don't create these problems that we see today. Department, honestly speaking, Advocate Kuta, I don't think it's good enough that we make a pronouncement that this board does not meet quorum when we have not established what the Act says about quorum. For me, that's the most basic thing. That is the most basic thing we can't make such mistakes. The Act, I mean, I deal with over 150 entities. But I knew Section 13, subsection 3, when I read the papers of the board, and then I knew that there was going to be an issue about quorum. I went to the Act, and I looked at the Act. What does the Act say about quorum? Section 13, subsection 3 is very clear on what is a quorum according to a NSFAS. It's not like any other quorum, as if you're attending a PGM. It's 50% plus one. No. This quorum is different. It's not. Yeah, it's no attending BGMs. The democratic organizations, they have BGMs to nominate candidates. Others, they are appointed. So democracy works differently this side. So those things, honestly speaking, they can make or break a decision of a minister. And the reason why those who came before us, they would have said a department will need a legal department or a legal section. It's precisely for this thing. When the minister says, this is the decision we are taking, legal should be able to say, Minister, on this one, I think let's rather do it this way. Because the opinion we have is that we'll fall short on this one. That's what people who came before us, Advocate, could have thought that we need a legal department for. The assumption or the reason that you have given in the slide as the first is that Route A, your Route A, that there was no quorum, Minister. My thinking is that might not be true because we don't know what is the quorum of NSFAS. What we know from the 17 subsection 2 of the what is called that the NSFAS, no, not the act, the book, the charter, the NSFAS charter is that at least we know the minimum people who must attend there are 3 EXCO members. And Section 13 subsection 3 indicates of the Act indicates that the quorum is set by the board. So the board would have set a quorum. And if you don't know what that quorum is, you will not be able to go out and say there's no quorum. And this quorum, according to the NSFAS, it's achieved in two parts. The first part is the EXCO members. The other one is in terms of numbers, which we have not established. While even this meeting, we have not established what was the quorum there. So legal of the department must assist the minister, Advocate Kuta. We should not, and Honorable Souls asked you, are you saying this board then did not have the legal rights to be a board? You said yes and no. Yes, because they are there, but no, because they don't meet quorum. And we know that was not correct. So we will meet sometime maybe next week after one of our meetings. We have a joint meeting next week, Wednesday, with Public Works as a result of the oversight we had in at the beginning of the year about Public Works not giving TVET colleges, CET colleges, and universities these buildings that we are renting from. I mean, we're supposed to be. We say we don't have money to fund education. We've got building, but we want to take money from this education institution. So why even that man? Maybe after that meeting, it's a joint meeting. Maybe after that meeting, we'll have our in-committee meeting so that we then decide, we take a resolution on what we have established there. But I think what I've decided to speak about, Minister, these are, for me, the basics that we must all agree that they should not happen again moving forward. You know, the relationship, you can tell, between the minister and the board is not really good. And maybe it's because we have 28 meetings in 1 year between yourselves. So you are meeting too much between the minister and the board. So we must work around these things. I think because there are professionals there. You know, there's 2 doctors and 1 advocate there who came here today. There's other advocates on the line and all of that. And other people, very serious people. You'll remember that the advert said minimum masters. So everybody would have went there, serious professional or academic, and we must try by all means to preserve what people have worked for, the reputation of people. So we don't want this thing that you know, there's these fights, unnecessary fights between the minister and people either in councils or boards of our entities. We must try by all means and find amicable solution. I'm a proponent of peace. I know sometimes I'm not looked at that way. People see something that I don't see in me. They believe that I'm probably this monster, but I'm a very peaceful person. Very peaceful person. So I believe in having cordial, not the piece of chiefs, no, the other one. No. I've got plenty of that, except the one of chiefs. So that's how we're going to close this team, members. Minister, what we want is that you guys are going to court on Tuesday, the 2nd, 2 June. Yeah, on the 2nd of June. All the best to all of you. Whatever decision whatever decision, no, Parliament doesn't take sides. Parliament listens to facts. We don't choose. You know, the office of the minister, they want to put me under pressure. They say I must choose. So, well, all the best. We hope that when the court makes a determination on Tuesday, we'll all accept. And then what is important, and this is the message, Minister, that would ask you and your team to communicate, is that this governance situation we find ourselves in will not affect students, will not affect people, the beneficiaries. On the 25th and the 31st, when we're supposed to, when students are supposed to get their allowances, they will get them. If they don't get them at the end on Sunday this week, well, maybe they'll get it today because it's the 29th. But if they don't get it today, then we're going to create a big problem in the society. That these governance problems are the ones that are creating these problems. We are extremely worried about that 2024, 2025 ages report, because it says almost 15,000 people had defrauded the state. That's what it says. More than 15,000. They may have not worked alone. They may have worked with some people inside NSFAS. But more than almost 15,000 people defrauded the state. And not only that, they closed doors for about 15,000 poor people who deserved to get funding, and they did not get last year. It also says there's more than 822 deceased people who are receiving funding. As we speak, they are receiving, we don't know whether it's full funding or it's only allowances, which is a big problem. These are in millions of rands, hundreds of millions of rands, DGC. It's a lot of money that we should be giving it to deserving students. I know there were comments being said here about people coming with their views on what must happen to NSFAS. The president during SONA did indicate, even 2 weeks back when he answered the question of Honorable Khabo, that we're expected to submit a comprehensive student funding model so that it can be approved, DG. That funding model, comprehensive funding, is extremely important. We have commissioned a number of reports. Earlier on, Minister, you were responding to Honorable Lonzi, and you made a mistake. You said it's a higher commission. It's actually the Prof. Balim report that speaks about cutting NSFAS at TVET colleges. It's Prof. Balim's report that speaks about that. So we do have these reports that we have commissioned, DG, but we're not implementing them. And it creates a problem. You see, for me, if we had decided to say, NSFAS, TVET has got 200 and something thousand students this year. Probably, I don't know how many last year, but we say we start with this one. So maybe let's try and implement part of this, the Balim report. And I can tell you, would be far by now. My view, I know that some people advise me not to say this thing, but my view is that, Minister, we might be dealing with organized criminal networks. They're stealing money from NSFAS. Very serious. Because let me tell you, if a person dies, the banks have got, you know, at the bank, you know, when they verify you, you put your fingerprint. They've got this biometric system that is linked to the Home Affairs that confirms if a person is alive or dead. So when we lose money from NSFAS and it goes into a bank account of somebody who's deceased, you must know that thing doesn't happen by mistake. Banks in South Africa with their technology are way too ahead. I made an example the other day, Minister, that when I went to Botswana for SADC education protocol in March this year, the SADC wanted to give me SNT. No, SNT. And when they wanted to send me SNT, my bank, because it was in US dollars and it was coming from Namibia, my bank closed it. And I thought, no. You know, Honorable Lonzi, tomorrow I'm going to a funeral. Ne? And in my township, when I go to a funeral, they like giving me guns to shoot. So I don't know whether I'll be like your president if they give me a gun. You know. But, so banks are like that. Banks knows. They've got these defense mechanisms to protect both themselves and yourself. So these people, when I say they are organized, it's because there's no way money can go into 800 people's accounts and the bank doesn't know. And if these people are deceased. Actually, you might find that this NSFAS money actually goes into one account. But the bank wants to know the source of your income. So the banks would have said, this money, where does it come from? And there they will see it says NSFAS. They've got other clients who are NSFAS, who are getting 1.7 per month. Why is this one getting 170,000? The banks will naturally ask. But because they are organized, they might be working with somebody who every month, their job is to turn off that red button when it comes on this account. And when we say, Minister, we must fix NSFAS, these are certain things that we must go and look at. We want to understand, how does this thing happen? Let's do let's bring in a serious security cluster in this country to go look at these things. Because it's a worrying factor, this thing there. And it might be done intentionally to collapse it. Because this NSFAS, by the way, has produced more than 5.5 million graduates who ordinarily will not have seen the doors of learning and culture, let alone to graduate. So this NSFAS has produced almost 6 million poor people from villages, far-flung areas, and townships. It might be, this might be one of the success stories of this government. And therefore, it might be, people might be wanting to finish it. Because why would you want, if you are against the progression of certain class, why would you want a vehicle that produces so many poor graduates? So we have to deal with those things. So, Minister, we need to attend to them. We might need to look at, security cluster, looking at that particular issue itself with proper accounting people to look at this thing. So I want to thank you, members, for you wanted something, Honorable Lonzi.
Before you close, Chair, I thought you would come back to us to do the usual quick round. No, just quick things. I think, Chair, maybe we'll process them through ANEL because they are important information that we said we want the board to submit based on the submissions that they're making as well as the department. Because we also because some allegations were made here about Florence, who called the board members and said that minister wants to appoint this CEO and that, and then there were some text messages and calls, and also I think we need the members, the board members, to submit all of those details, and then the last point I want to check with the other board members who are present in the meeting, because I agree with Honourable Joy that we may need to sit, and you've also agreed, thanks Chair, we're going to need to sit a meeting of our own to understand how do we get to the bottom of truth in a recordless meeting. And by that, part of that would be to try and contrast the different versions. So I wanted to then check with the other board members who have not spoken, so that we don't make an assumption that the one board member who has said that the minister gave them an unlawful instruction not to proceed with the appointment, and automatically assume that all the board members who are present in the meeting agree with that. So I wanted, as a parting shot from my side, if we can go through very quickly to each of the board members to confirm if they align with this version. And then that's it, Chair, and then I'll be happy. I'll send my questions to Anel.
Okay.
Just a smaller clarity, Chair. The reference that was made to Ms. Florence Masebe, it's actually not the person who called. Her name was dropped or was mentioned in the conversation. I just want to clarify it that at no point did I receive a call from Ms. Masebe.
Yeah, there was a name dropping issue. Don't worry, I'm told somebody also, Minister, somebody was also name dropping my name and yours, So this issue of name dropping is it's common, but they agree that because if they did not agree, they would have said no. But you agree with the version that
yes, no, yeah, we've agreed, and we've submitted also the affidavits to that effect for a court case.
Yeah,
thank
you. They all of, including you.
Yes, Chair.
Yeah,
we do agree.
There's Advocate Lavan. You also agreed with that version.
To all present, correct. I also agree to that version. Thank you.
Okay. No, thanks. Honourable Maimela.
Thank you, Chair. I think.
Sorry, Honourable Maimela. Portia's iPhone.
Chair, I did earlier on agreed with what Advocate Ramaswamy had said.
Okay. No, thank you. Just wanted for Honourable Lonzi's record keeping to hear you guys say it. So everybody has agreed to that effect. Honourable Maimel, I'm sorry I had to cut you short there.
No problem, Chair. I think in addition to a discussion or a reflection on how we move forward from this meeting, I think we might also like to use that meeting, as Honourable Karabo had said earlier, to discuss how we conduct our question and responses or engagement sessions, so that we don't do the same thing we did to you earlier, where we wanted to different things and how we approach the session. So I think we might also want to add that. But Chair, I also want to request that as we request the written responses, we might want to write to the people who have mentioned, especially the board members, the former board members. I'm not worried about the other person that was mentioned. I'm worried about the person who was directly a part of the process. The other board member to say these were the allegations. We'll go on record to say exactly what was said, and get a response, a written response, their written response, even if they don't appear, so that when we do have that engagement, we've got a full picture. Lastly, I know that Honourable Advocate Ramashi, I've been saying Mr. Apologies, Advocate. Advocate Ramashia said something about Mr. Masoha, and it was so I just want that what he mentioned, if he said it's a WhatsApp text, and it says something about Mukoni, and I wanted to get clarity so that I can write a written question on that message. If you can just the exact words that were used in that thing, so that I can write a question. So for written responses on that question, on that message.
I think you might have said Moshabi, I don't know. Advocate.
Chairperson, it's actually none of the two. The text reads Moshate.
So you are from the royal space.
You're just being generous and elevating me.
Okay. You heard that, Honorable Maimela, right?
But the message in all, I just the message, because it
Okay.
was a short message. If you can indulge me, Chair.
What I said in relation to Mr. Masoa is, on the 28th of March, I missed a call from him around 12:55. I text back, leadership, I saw the call. I'm a bit under the weather. May I please call you back tomorrow? He responds, Moshate, can I please steal your 2 minutes to brief you briefly about my issues? I'm just a messenger and due to meet the principal shortly. Thanks. This was at 17:59. I didn't interact, and then the last time he came back was on the 20th of April. ATA, do you have a moment? If you have got a moment, kindly bounce back. Thanks. Show leadership, I will later. Then I called him for a call that lasted 3 minutes at 17:52.
Okay. No, it's fine. Moshate, we appreciate. Honorable Msezane.
No, thanks, Chair. Maybe, Chair, from my side, it would be for us to get a written response from the Minister or from legal Advocate Puta regarding the legality of a minister calling a meeting, a formal meeting without any records. Would want a response, a written response from her as a legal person, but also from the minister having seeked guidance in terms of legislation, or if that's how they conducted their formal meetings. The concern really, Chair, is about how do we then account for the legal, for the public funds that are used in these meetings if they are not recorded. So it was mentioned by the minister that they do conduct such meetings where they don't have records. So it's very concerning. So would want to really get a response in writing in terms of that. Thank you very much.
Yeah, no, it's fine. We, like I said, on Wednesday we'll have our in-committee meeting where we will develop a number of questions. Well, firstly, we'll agree on how we are, what will be our view on what happened here, and then the number of questions that we'll agree on in that meeting, the in-committee meeting next week, Wednesday, we'll then write to the department and the ministry to respond. So there's no need for them to respond now. We will take that decision as a committee on our own, and then we will then write to yourself. So want to thank you. I know some of you are rushing for your flights. I want to thank you for coming.